Lena Hornkohl, Matthew Cole, Christian Bergqvist. Very well, welcome to Digital Markets Research Hub, and I'm sincerely grateful not only for your expertise, because we will be discussing today Google Shopping judgment of the Court of Justice Grand Chamber, but also for your availability. You literally allocated hours within these few days, and maybe even changing many different plans, etc., in order to have this express discussion just as the judgment is still fresh and hot, actually. So we will revert to technicalities, but obviously it would be better to start with reminding to ourselves and to students maybe the context, because the context defines many situations. And we decided on the technicalities that we'll be rotating the order of those who start and those who conclude. And maybe we start the first round with you, Lena, if you don't mind, just highlighting the key factual circumstances of the case.
Yes, well, the case started in 2009, I think, with a complaint from the industry. So, and I think multiple complaints. Funny fact, I started my law studies in 2009. So you see, the case is going on for a long time because I did a whole law degree and all the other stuff. And I'm a professor, and Google Shopping has been going on ever since then. Started with a complaint to the European Commission. The commission started investigating, and at first they wanted to close the case in a commitment with a commitment decision, but the commitment discussion failed. And so the commission moved this whole case over into an infringement proceedings, which took a while. And in 2016, the first the commission decision came out on the case. Of course, Google appealed in 2020. I think we had the judgment of the General Court, which upheld the commission decision to a very large extent, and by using their full discretion, even though in a small part, and we talk about it in a second, I think the General Court found an error of the commission. It still upheld the whole fine. Of course, then there was another appeal to the European Court of Justice about the judgment we talk about today. Advocate General Court already delivered her opinion this year in January, and now 8 months as usual. 8 months it takes for the court to decide after the Advocate General. We now have the final decision of the Court of Justice, and the whole EU judiciary basically, or to a large degree, upheld the initial commission decision. So I would say that's a good wrap up of what's happening. Now the case is closed, and we'll see. It goes on probably into private enforcement. So maybe my whole judicial career, Google Shopping will stay around.
We will see. Christian, what do you like to add to this introduction?
I would like to start with one of the comments Lena made, and that was there were some elements of DG Comp's decision that was not upheld on appeal, and that was one of the motive. And Google had two motives. They wanted to monopolize a more profitable service that was comparison shopping, but they also wanted to defend the crown jewel of the empire, that is the search engine. And I actually think that the reason why I start by that is because I actually think that it's easy with the benefit of hindsight to ask, why did it take so many years to rein in a company that so obviously are guilty of anti-competitive behavior? But I think, at least I don't have a problem admitting it myself, but I think that most people, including many enforcers, didn't really understood what was going on for many years. And that is the simple explanation why it took so many years. Because DG Com was struggling to build a case that they could understand and they could defend. And obviously we don't know that, but we do have some clues, because in the US, the Federal Trade Commission closed the investigation in 2012, and subsequently the document has been released. And when you go through the document, you can really see how the civil servant has mixed feelings. They think actually there is a problem, and they also believe that Google is acting anti-competitive, but they don't think they can win the case. Essentially because they cannot explain to a very old judge who has been, lectured by Robert Bork that there is a problem. And in America, they have a very limited catalog of theory of harm. So this would actually be refusal to supply, and the case law does not really support a refusal to supply case. In Europe, we have a much broader catalog, and we do not to the same extent need to establish anti-competitive effect and consumer harm, but you still need to build a case that you can explain. And I think that is the reason why it took so long for DG.com to start opening the case. Also believe that what happened was that in 2013-14, DG.com restructured the case, decided rather than focusing on a lot of services that was being monopolized, they only focused on one, and that was shopping. And they also made a blend of two theories of harm, that is self-favoring and maliciously downgrading. And that paid off this week.
Thank you. Matthew?
Yeah, I mean, it's just amazing when you think that how long ago the actual behavior this relates to occurred. I mean, we're talking about when the first commission decision came out and the General Court and now the CJEU, but to think that the actual behavior that this relates to actually started around 2005 to 2007, or around that point that we have issue. I mean, that's a long time ago. That's just short of 20 years ago we're talking about, essentially. It's just amazing. I mean, like you say, as Lena said, what I was doing in 2005 and 2007, I was probably just making it into law school at that point. And this is a very different world. The iPhone hadn't actually been invented when some of these things were going on. So it does, unfortunately, although it's wonderful that the case is now closed and the whole thing is dealt with and we have something which could perhaps become reliable precedent, it does go to show that the glacial speed that this has moved is a bit of a problem, because you have to actually take yourself back to almost a different world to think what technology and what markets were like all the way back then. So it doesn't it doesn't bode well on one level, but on another level, it's good that it's finally dealt with.
Excellent. So let us move to the case, and I propose again we do it highlighting the key finding of the Commission, and then the General Court and the Court of Justice, the latest one. Christian, let us start with you, reminding to us the key findings of in the Commission decision.
Okay, I think the Commission did a very wise decision when they restructured the case, focusing only on one services. If we look at the name of the Commission decision, it's actually quite interesting because the name is Google Search Shopping. And I think this speaks to that initially there was a whole series of decisions about different services, all of them named Google Search, and then another service that they tried to monopolize, that would be shopping, maps, jobs, etc. And I think they made a prudent decision focusing on shopping, because shopping is a service that makes a profit. And you should always follow the money. I also think that the Commission did a very wise decision with this, rather than focusing on self-favoring, which I personally don't believe is abusive. They blended in some kind of malicious downgrading, and that is that Google's own offering is not run through the algorithm. And once the algorithm identify a competitor, they downgrade it. Now, Google denies that, but when you look at the graph, it does look suspiciously. However, DG.com, in my opinion, forgot to update all aspects of the decision, probably because they ran out of time. So when you read the decision, there are some confusions about what is actually the abusive behavior and what is the motive. The motive is twofold. First of all, they want to monopolize, Google wants to monopolize a service that is profitable. That's easy to understand. But there's also a secondary and much more defensive motive pertaining to the risk that comparison shopping, which is a specialized search engine services, can be developed into a general search engine, thereby challenge Google's monopoly. that is a fear that goes back to the Microsoft case, and I think there's something to it because it was actually advanced in the Google Android case, but DG Comp didn't really develop that. And they also forgot to align the definition description of the abuse across the case. In some aspect, it is defined after self-favoring. In other, it is the blend of self-favoring and the demotion. So when you read the case, there are some confusing elements. And obviously, with the benefit of hindsight, and we understand things much better now, it's easy to point out the mistake. I'm not saying that I could have, done it better, but I think it could have benefited from, some more internal review. And that means I came out a decision that that looked convincing, but when you went through it, there were elements that could be debated. And I think that the General Court corrected all of these things and added some other stuff. But in generally, I think the Commission did a really good job, but it could have benefited from a little more time to make all the element across it more consistent. And of course, there are a lot of things we don't know, but my guess is that they ran out of time. And that is the explanation for there some incompleteness in the decision.
As we already hear, in a nutshell, can you give us a rule of thumb distinction between self-favoring and malicious removal?
But self-favoring, if you and I went for a drive in my car, it would be obvious that I was in the driver's seat. When you list something, why shouldn't it be your own offering on the top? So self-favoring is so normal, and particularly in the digital economy. And I don't think it in any way can meet the requirement of being not competition on the merits. But Google had an algorithm, the Panda algorithm, that was designed to clean up the internet because there's so much crap on the internet. And it was used to, remove things that are not what I'm looking for. And the Commission's position was that Google had put something in that algorithm that identified competitor and instantly downgraded them. So there was a blend. The self-favoring was that only Google's own offering came with pictures on top. The competitors was referred to the blue link. That I do not believe is abusive in itself, but it was not only referred to the blue link, it was actually referred to, page number 2, 3, and 4, and nobody goes to those.
We know Margaret Vestager metaphor about page 3, 4.
I should underline, this is my reading of DG Comp's decision. There might be, I know there's other people out there who have a different position. We can also see that because in the draft guidance paper, the Commission peddles the idea that self-favoring is abusive in itself, which I do not believe, but this is based on my reading of the decision and the subsequent rulings.
Okay, so we continue with chronology, and after the decision was appealed, the General Court held its judgment. Lena, can you please summarize to us?
Yes, so overall, Google raised 6 pleas at the General Court, and the General Court, also reallocated it a little bit and grouped them together. And I think the General Court decision has 4 main parts. In the first part, the largest part, I would say, deals with the sole question: is this competition on the merits? What Google is doing, and what are the conditions for this abusive behavior in order to be abusive? And Google kept raising that, it was about gaining access to these shopping boxes, and the shopping boxes can be considered as infrastructure. And because also the remedy is about giving access to, or at least, could entail giving access to these boxes, that means that also the corresponding abuse can be compared with the refusal to supply. So that's what Google raised. The General Court did not agree. They said, it's its own distinct form of abuse, which can have some elements of giving access, as many abusive behaviors require giving access afterwards in the remedies, or they have some kind of discriminatory elements, which in itself is not sufficient. But the General Court followed that these criteria that previously been adopted by the court in Bronner and the Bronner decision that were upheld many times afterwards in comparable situations, which were considered refusal to supply or refusal to give access, did not apply to this condition here, or to this behavior of Google in the Google Shopping case. So the majority of this first plea dealt with that the disapplication of the Bronner criteria, or it even had a section on, like, even if Bronner would apply, then the conditions would even be fulfilled. The second plea then focused on, that this is a distinct form of abuse. Sometimes, and also the decision of the General Court is not super consistent, I think. They call it sometimes, discriminatory abuse, abuse of leveraging. They never call it self-preferencing, as far as I know. It is only, the literature and everybody who talks about it who now calls this type of abuse self-preferencing. And I think there I agree with Christian, just calling it self-preferencing is not enough, because what also the General Court said is that you need to have some kind of, more than just self-preferencing. It needs to coincide with this, malicious downgrading or discriminatory downgrading. And of course, it needs to coincide with anti-competitive effects, which the General Court analyzed in much depth. The last plea that was, or the last part of the General Court's decision, focused on objective justifications, which were also dismissed in that instance. And as I said earlier, there was one small part where the General Court considered that the Commission had relied on too imprecise considerations when it came to anti-competitive effects in national markets. And in that aspect, it found an error in law, but using the unlimited jurisdiction that the General Court had, it still upheld the fine as it is. But there was this small, error in law in national markets, because apparently the considerations were too imprecise.
Thank you very much, Lena. Matthew?
In terms of the Court of Justice of the European Union's final case, it was appealed on four bases, and there was many kind of sub-arguments within those four grounds, but essentially the first one was, once again, that this was actually to do with the supply of essential facilities or refusal to supply, and so it essentially mischaracterized what was going on. The second appeal was that they mischaracterized whether the behavior was competition on the merits or not. The third ground was essentially whether they'd sufficiently proven any sort of causal link. I'm sure we'll discuss it a bit later, but interestingly, the complaint seemingly was that they'd focused too much on effects, or that was one of the things which was issued. And then finally, that the General Court had made a mistake because it hadn't appreciated that it was essential to conduct an as efficient competitor test as well. So these were the four grounds. Like I say, within that, there's many sub-arguments, and you can get into a great amount of detail, which the court does over almost 300 paragraphs. But essentially, it can be summarized nice and easily that the Court of Justice said no, 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 and flatly refused everything that Google had argued, and said in each case, essentially, the Commission and the General Court had done things correctly, that they'd done things well, and the appeal was dismissed in its entirety. So I imagine that was a very, very good morning for Margrethe Vestager.
Yeah, because it coincided with another, so it was very important morning for her. Yeah. And I propose we look at each of these four grounds in sequence. But before doing this, I propose a short round this time again on what was at stake, in both in terms, we somehow understand the context, but how different the trajectory could be turned should the judgment of the Court of Justice be any different than it actually was. Let us start with you, Christian, then Matthew, and then Lena.
So you want to do a counterfactual analysis? I don't think it would have had big legal consequences if it had been overturned. I don't think that was a realistic option because, you know, in most aspects, I think the outcome was a foregone conclusion. There were certain elements in the general courts that I didn't like. That was, of course, the reference to super dominance, sense of facility, and search neutrality, and that was actually gutted by the Court of Justice. So I think that in almost all aspects, the ruling is as I would have drafted it if I was invited to it. But obviously, it would have been embarrassing for the commission to be turned over, and you know, Vestager's tenure is ending, and she wouldn't have been happy to leaving with a big loss because she kind of built her reputation on being tough on big tech, and if that is overturned, that would be problematic. It would have been a big win for Google because, you know, even though they're out of appeal and the case is over, there's a lot of claim for damages out there, and I'm tracking a handful where some of the victims are claiming compensation. So it would have been a huge win for Google, and in my opinion, politically embarrassing for DG Com, but legally manageable.
Great. Matthew?
I think the chance of the commission losing outright would have been very low. I think on the vast majority of the things which were being appealed, I don't think Google had a particularly strong case. That's my opinion, at least. And so I would have thought the chance of them really losing, I mean, particularly when you think it's gone to the General Court has broadly supported the commission, it's gone to Advocate General, the Advocate General has broadly supported both. I think Google were always going to be up against some serious headwinds in getting anything which looked like a win. What I think they would have been quite pleased with, and I think what would have been disastrous for the commission, is if there was a sufficient technicality, some kind of step which perhaps was overstepped, or some part which was required, which was missing. You should have considered counterfactual and you didn't, therefore the whole thing has to be remitted back, or something along those lines. It would have been disastrous for the commission if some technicality that Google had found managed to stick and that somehow damaged the decision. Because I think realistically for Google, they can play the long game, which is funny because you'd think that a public authority would be able to do that better. But Google obviously have huge amounts of resources. They have huge amounts of profit. They can afford to supply their legal team with, as much money as they need, as long as it keeps them making profit. So I think the alternative disastrous scenario would be that the Court of Justice said, okay, broadly, yes, this is fine, but unfortunately they're right. You did miss this, or you did discuss that when you shouldn't have discussed that. And because of that, something could have been changed. And I think anything which delayed it even longer than, like I say, the 20 years pretty much it's been taken to do, would have just been embarrassing, and it would have made EU competition law look quite ineffective. And I think that would have been the disastrous outcome.
Okay, lovely. Lena?
Well, I mean, I'm just happy we don't have another Intel situation where we go through another round of, appeals. So I think that's what Matthew is saying, that, that could have been the outcome, finding some kind of technicality, and then it goes back and it goes on forever, which is basically what happened in Intel. From like a purely, let's say, legal or academic side, I think the implications is just that at least, we've been talking about self-preferencing for, I don't know, ever since the decision basically, or even before. And if you want to hear or want to read on a very different view, I think the lawyers of Google, they published a paper back in the day of what they think, or how they think self-preferencing is not a distinct theory of harm. And now at least we know that, okay, it is not a distinct theory of harm in itself, but it can be under certain conditions if certain additional circumstances are fulfilled. And I think that gives some way of legal clarity. And I also think that the implications are important because we have a lot of quite some national cases running on comparable behavior with other companies who basically rely on this commission theory. And we basically have the commission theory copy pasted in the DMA. So I think it's good to have this kind of at least legal clarity. Like if similar conditions like in this case are fulfilled, then we can find an abuse, and I think that's good for practice in the future.
Lovely. So now we go through all these four grounds in more detail, and the first round order is Matthew, Lena, Christian. Matthew, please, the first ground.
So the first ground related to whether it was actually a refusal to supply case or not, and this is essentially an increasing tendency among defendants in competition law cases in the EU to treat the Broner case, the Oscar Broner case, essentially as a defense rather than actually a particular type of abuse. The idea that if you can find a way to make the allegedly abusive conduct fit within refusal to supply, you've almost won your case. Because if it does fit within refusal to supply, it's so difficult to prove that what the commission wants is indispensable that essentially you're probably going to lose your case. So funny enough, like I say, refusal to supply should be a type of abusive conduct. It's almost become a type of defense now. And so there seems to be a tendency to try and find any way to shoehorn that particular behavior. So, you know, if it's tying, you might say, whoa, this isn't really tying. This is that you're refusing to supply unless you also buy this other thing, you know, or let's say it's an exclusivity agreement. You say, well, it's not actually exclusivity. It's a refusal to supply with that, you know, there's any way that you can try and make some sort of abusive behavior look like a refusal to supply. And I think this is what Google tried to do. They said, look, this isn't really about us treating you in a discriminatory way. This isn't really about self-preferencing. Really, there's a box at the top of our search, and you want to be in that box. And because we're not allowing you to be in that box, this is refusal to supply. And of course, this wasn't bought by the court. It said, no, not really. What this is about is the discrimination, the way that you are essentially giving yourself a free pass so that you are always at the top, you are always number one in the search results, while everyone else gets demoted because they are essentially subject to competition to a certain extent, and you're not. And so it's more differential treatment. And it's all really to do with the access to the general results. So they also pointed to the remedy and said, look, we're not going to force, if this was truly refusal to supply, the remedy would be that we would allow those competitors to join you at the top in that top box. And I said, that's not what we're doing. And so that was just another point that they made to say this isn't refusal to supply.
Thank you, Matthew. Lena?
Yes, well, you know, in my real time, I'm a private lawyer, and I think, or private law lawyer, and I think that's the distinction that also in this case, you know, the Court of Justice brought forward why it was not a refusal to supply. It makes this case that, you know, a refusal to supply or giving access to infrastructure is only relevant when, you know, or it makes this example from Bronner, when Bronner created this whole infrastructure just for themselves, and they didn't give access to this infrastructure to anybody. And the case here is really different from Google. They gave access, but the conditions were discriminatory. And that's where the court makes a difference. And they bring forward this private law reasons, for example, because giving access to something or contracting, supplying somebody you don't want to supply with is problematic, you know, from a private law perspective, rights to property, freedom of contract, all of this. And that's why there are very high barriers if you actually do not give access to something that is indispensable. The situation, and I think the court is right here, is different with Google because they give access. So the access is generally given. It's just, and I think Christian has explained this earlier, it's just, you know, they're on the second or third page. They're not in this box. So the access that is given is less favorable or is, as they call, discriminatory. And that's why in the court multiple times, I would say, reiterates that Brunner doesn't need to be fulfilled. This is not about refusal to supply, refusal to give access, because in many instances or in many different types of abuses, their access can play a role. Only if you don't give access and then your infrastructure is indispensable, then we talk about the specific situation. However, if you give access, there can still be and the court calls this an independent form of leveraging abuse in specific circumstances. So also there, they don't say, well, self-preferencing or discrimination is always abusive. No, we need to have additional conditions, or they call it here particular circumstances that they described that add on to the discrimination. And that's why, in my view, they create this new form of abuse that is distinct from simply refusal to supply.
Thank you. Christian?
I don't understand Google's position. That is the short version. I completely understand why they try to shoehorn the case into refusal to supply doctrine. I think Matthew explained that very good, but I think that was a loser position. Now, it is always easy to say that I could have done it better. That's not what I'm saying, but I think that it was unrealistic they could win on that argument, because this is obviously not a refusal to supply case. Now, I have a theory, but it is only a theory. So, please don't, And that theory is that Google's initial position was that this is refusal to supply, and I think that makes some sense if you're confronted with a self-favoring theory of harm, because that would be a refusal to supply. And I think that Google decided not to change their legal position at a time where I personally think it would have been prudent to do that. And the second element to my theory is that this is also a very American approach. In America, you have a very limited catalog of theory of harm, and most of them evolve around refusal to supply. So had this been an American case, it would have been logical to maintain that this is about refusal to supply. And this is an American company, and an option could be that group legal decided that this is a refusal to supply case, and then they simply instructed the lawyers. But we don't know that. But reading through the case, it looks a lot like there's a heavy influence by American thinking.
Thank you. Let us move now to the second round, and the sequence is Lena, Christian, Matthew. Lena, please.
Mm-hmm. Yes. So for me, the first and the second rounds are a little bit connected, because it's the other side of the medal. They say, well, it's not refusal to supply, so what is this in the end? And here Google raised several grounds for appeal that, focusing on what Christian also said at the end, that we have a definite list of abuses, and, discrimination is not in there, or it is not covered, even if then the conditions that the Commission and also the General Court brought forward are not sufficient. And the Court of Justice, I think, takes wind out of all of these arguments by really saying that, there is a form of discriminatory abuse or discriminatory leveraging, as they call it sometimes. I would call it, leveraging plus or discrimination plus, because they focus really on the circumstances of the specific case. So it needs to be something more than simply discrimination. The Commission found specific circumstances, or looked into specific circumstances of the case. So, for example, looked into the traffic that was diluted from the one side from the general search engine to the shopping boxes, and then also away from other comparison shopping service. They looked into the behavior of users searching online. So this is just famous, nobody goes on the second page of Google. And then they looked into, the impact of this diverted traffic and the user behavior on how much specific pages were used. And so taking all of this together, so the discriminatory element, taking it away from this panda algorithm, the Google's own shopping boxes, and then all of these special circumstances taken together would not be competition on the merits anymore. Funnily, again, we still don't have, a positive definition of competition on the merits by the Court of Justice. In paragraph 164 of the judgment, they try it. But they define it in a circular argument. They say competition on the merit is when, when you don't behave competitive anymore, which is basically the same thing. So it's not really a definition. So I would say, or this is my reading, that they create this discriminatory plus abuse, and you need extra circumstances. And in the Google case, we have a few of them fulfilled, or a few fulfilled, but that doesn't mean that they have to be the same circumstances in all of the cases. And then there were some additional points raised, but I leave them for my colleagues for now, so I don't monopolize the discussion.
Thank you, Lena. Christian?
I don't want to defend Google, but there are some merits to some of the claim, and one of them is that they introduced the Panda algorithm to clean up the internet. Because whatever you search, you find a lot of stuff that is not what you're looking for. So it does make some sense to have an algorithm that make corrections saying this is probably not what you're looking for. And in most situations, nobody really object to the fact that this is downgraded. Problem is, of course, that the commission presented some evidence in terms of internal emails and suspicious graphs indicating that Google intentionally targeted competitors. But if we ignore that for the moment, Google's action is that only their own services comes with pictures, which I think makes some sense. And competitors has to go through a corrective algorithm because Google don't know who they are, and they can vouch for their own services, but they don't know about the competitors. So there's actually a lot of the stuff where you could argue that what Google has done is actually legitimate and competition on the merits. So I think there is actually legitimate arguments, and Google, of course, put them forward. Personally, I do not think that they were convincing because there are certain patterns that just simply look too suspicious, and I think that was the problem. But if we ignore that for the moment, I think there was actually a line of argument that what Google is doing is just simply competition on the merit because self-favoring is such a natural thing. And when you are running a search engine, you want to provide the best results, and people do not want irrelevant stuff. So of course they can demote them and move it away. But the blend and the fact that there was something that to me looked like they were malicious, and that actually created a situation where this was not competition on the merits.
Great, thank you. Matthew?
I agree with Christian on quite a few things he said there. I think to a certain extent this might have been Google's strongest point. I think part of that ties into the idea that if you think of a normal business, people would think of self-preferencing as relatively natural. So if you think you go to the supermarket and you've got the supermarket own brand beans and you've got the Heinz branded beans, if the supermarket wanted to put its own beans at eye level, technically that would give them an advantage. They are self-preferencing. They are putting their products in the best place to sell it as opposed to other third parties. And if you said that to someone, should that be illegal? They'd probably say no. But I think there's a number of things which distinguish what's going on with Google here. And part of that is to do with the fact that Google is dominant, whereas most supermarkets are not, and things like that. But I don't want to get too carried away with that. But what I will say is, yes, I think this is where they had their strongest argument. The interesting thing is, though, Google, as far as I can see, was also kind of saying, quite an unusual thing, which is, what is it? What is it exactly that you are accusing us of? Because what it seems to be is you're focusing so much on the effects. You're saying the problem is that traffic got diverted from our competitors to us. And it's almost as if that effect in itself is enough. And I think my reading, at least from the court's decision, is partly Google just saying, so what exactly are you accusing us of? Characterize what self-preferencing or whatever it is that you're accusing us of. Say what that is, because I think it's actually quite difficult to come up with a legal test to say this is when self-preferencing is bad and illegal and you can't do it, and this is when it's fine and we don't care. And I think that's what Google's trying to elicit, that kind of difficulty in nailing it down. But as it happened, the court didn't really buy into that much. They said, look, they've set out the circumstances, they've set out not quite a test, but they said they looked at the importance of traffic for Google's competitor services. They looked at the behavior of users, i.e. they actually stopped going to the ones they were going to before, and that this traffic can be replaced. So it's an interesting point, because that's not really a test. That's not a complete test. If you wanted to explain to your students, this is when self-preferencing will definitely be illegal, and this is when it's not, that isn't enough. But it was enough on the day, and the court did accept it, and they said these conditions are sufficient to show there is abuse. And I think the behavior is abusive. So in my opinion, at least, I'd say the court made the right decision. But it's interesting that I don't think this is really fully formed. And it would be interesting if they could come up with a more specific test to say exactly when this sort of behavior is bad and exactly when it's not.
Thank you.
But let me jump in here quickly, but isn't it, you know, this is normal what we do as lawyers, or this is normal in law, I would say, that you have some kind of minimum standards and then you apply the case to the specific case at hand or the specific situation at hand. And here I would say you have the test of being like discrimination plus. You need more circumstances than just simply the discrimination. And I've heard the supermarket example so many times. Every time we talk about self-preferencing, people talk about the supermarket. If a supermarket puts their own products in the top of the shelf, everybody thinks that's normal. Yes, that is normal. That is just the self-preferencing. There we don't have the plus element. But, you know, if the supermarket would then go and, you know, in the cereal aisle, only put their product on top, hide all the other products, make it very difficult in terms of lighting and so on. So you have always extra elements. And I think the decision makes it clear that you need multiple extra elements plus this self-preferencing, and then we have a problem. And so I think at least we, you know, move into the direction of having more legal certainty in the sense that, yes, the supermarket example, we are fine, but if we have additional elements, then we have a self-preferencing abuse. And in these situations, it depends on the situation in the case, because you just need something extra. What that extra is different in situations. And maybe down the line, you know, if in 10, 15 years, we've had more self-preferencing cases at the court level, then these extra elements will be different in different cases. And then we know more about these extra elements. That's just what I wanted to add.
No, I'd agree with that. I think there's the difference between putting the cereal boxes further down and then putting them in the basement or, you know, in the shop next door. So I would agree with that. And I'd probably agree, and that's kind of what I'm hinting at, is it would be interesting if there were more of these cases, if they'd actually isolate a little bit more clearly what that plus is. And that is the thing that I'm kind of interested in. Whether anyone can come up with a nice pithy test which tells you what that plus is, I don't know. But I think that was what Google was trying to scratch at. They were trying to undermine the case by suggesting, you know, you can't even tell us what that plus is. So is this a real abuse? But I totally agree with what Lena's saying.
Great.
And then maybe if I before we move to the third ground, if I can add one more thing, because I think the second part of the grounds of appeal was that, you know, Google brought forward, well, but then you put things in like the notion of super dominance, and you put things in like you compare it with this internet access internet access regulation, and that Google is kind of, giving access to the internet altogether. And I think that was also a bit part of that second round of appeal. And I think that is precisely what you're saying. Like, okay, does this always need to be fulfilled? So do you need to be super dominant in order to be, have leveraging abuse, or do you need to be like an internet access provider? And there I think the court said, well, no, that was just additional elements that were considered. So what the Court of Justice said, it was already enough, to have this discrimination plus, diverting the traffic and so on, what we talked about. But super dominance and all of these things were just something extra considerations, but not decisive. So at least, we don't need super dominance. We don't need internet access provision. You can rule that out from the list.
Thank you for this. The third ground is Christian, Lena. So Christian, if you want to reflect on the latest, please feel free.
Yeah. I think it's not helpful that DG Comp peddles the idea that self-favoring in itself is abusive. I've seen that in a number of conferences, and it's also in the draft Article 102 paper. So that probably also, add to the confusion, because, it would have been helpful. Of course, they would never done that, but it would be helpful if the commission says, we don't think self-favoring in itself is abusive, because then we have sort of closed the discussion. We didn't really need to identify when is self-favoring as abusive. And I don't think it can be abusive, but obviously I understand completely the different opinions out there on that. When we come to the third ground of appeal, that is where I'm really, that is the one element of that case I've been struggling mostly to understand. But I think it goes back to the market definition and how you sort of have two markets and two services. That is general searches, which is, Google is king of that. And then you have specialized service, which, there's a lot of competitors. There is a link, and the link is that, specialized service provider are not only a separate market, but they are also to some extent dependent on traffic from general searches. And going forward, it might actually be able to, morph your specialized search service provider, and then you can actually develop a general search provider. So I think it goes back to the fact that you have two clearly separate services that nevertheless are really connected. And DG Comp put forward a lot of suspicious graphs that indicate how Google are, depriving competitors at the specialized service, that is a shopping, from traffic. And then they argued that this is anti-competitive effects. But DG Comp had not established that they actually had foreclosed. So I think Google probably says, well, you argue that there's anti-competitive effects, but what you have proved and what you have put forward doesn't really prove that. It only proves that it has potential anti-competitive effects. And, we're not necessarily denying the traffic is disappearing, but how can you argue that that is actually anti-competitive? Because, how do you use the internet? In some situation, you start by Googling things, but if I want to shop something, I just go straight to Amazon. And, after the case came out, I also go straight to Fountains, which is one of the plaintiffs. So I think there's some argument that can be presented that, the commission says there's anti-competitive effect, but they have not really established that. They have not established foreclosuring. So, that is what I understand that the argument was about. And then, of course, the General Court and the Court of Justice says, well, potential anti-competitive effect is sufficient.
Thank you, Christian. Matthew?
So in terms of the third ground, if, like I say, I might not be understanding this correctly, so I apologize if I get it wrong, so feel free to correct me if I am. But I think to a certain extent, this was a focus on causation and counterfactuals. So I believe there is case law which says that if you are looking for abuse, you need to apply the counterfactual. So you have to consider, right, this is the situation if the behavior occurred, and this is the situation if the behavior didn't. Now, my understanding, like I say, I apologize if I get it wrong, feel free to correct me, but my understanding is the commission never spelled it out that it did a counterfactual. So when the commission was making this decision, it never said, right, we are going to specifically consider a counterfactual situation now, and we're going to look and we're going to say, oh, look, this would be the situation without the behavior, this would be the situation with the behavior. Or exactly in the right way, because there's essentially two different behaviors and you can break them down in different ways. And because of that, Google is saying, well, you haven't really sufficiently used the counterfactual, you haven't used it correctly, therefore the decision is valid. I think what the Court of Justice did to avoid getting too bogged down in the exact technicality of whether a counterfactual was used or not, they said, really, this is about causation. Has causation been proved? They have set out an argument. They've set out a clear argument. They've explained how the behavior of the dominant undertaking has had this effect and how this is anti-competitive. And so my understanding is essentially they were fussing less about whether a counterfactual per se had been used and more about whether or not causation had been proved. And they said, for us, this is sufficient. Yes, they have made an argument, it's reasonably structured, and so it is fair for them to have shown causality. I think that is roughly what they were talking about in the final case.
Thank you, Matthew. Lena?
Yes, and I think the last part of this third round of appeal focused on then, we will bring it forward. We have shown with the study that at least in one of the scenarios, or one of the two scenarios that were by the Commission as a combination seen as abusive practice, for one of the scenarios, we demonstrated that we demonstrated that there was no impact, and here the court held, and it reminds me a little bit of, in 101 we have this single and continuous infringement where we don't have, one cartel, and then every time it's a different cartel, but you see everything together as one single and continuous infringement. And that's a little bit what the Commission and now the General Court and the Court of Justice are doing here as well. At least it reminds me of that, is that they say none of the practices that you see, so not the promotion of Google's comparison shopping service in itself and then demoting the competitive in itself would be abusive, but just the combination of both. So it's a little bit like the single and continuous infringement, both together reach these effects, and then that's why they both also have to be analyzed together. And the Court of Justice backs that it's not sufficient enough to simply say, well, in one of these scenarios we have a study and it shows that there are no effects, but you need to then basically say in both combined practices or both combined effects, you need to demonstrate the counterfactual.
Thank you very much. We move now to the fourth ground, please, with the order Matthew, Lena, Christian.
I've actually got an awful lot to say about the fourth ground, so I'm not going to say it now. I'll kind of save it a little bit later, so I don't kind of take over and talk for too long. So I'll just kind of summarize what I think the fourth ground was about. There's very much an increasing habit and kind of desire to make the EU competition law more economically focused or economically rational. And in order to do that, lots of this is focused around the idea of using an as efficient competitor test. So in this, Google said, you always need to do one of these. You haven't done one, so therefore you haven't applied the law correctly and it should be replaced. Like I say, I've got an awful lot more to say about that, but the court's response in the short term was they referred to Intel and they said, actually, for us to have to apply an as efficient competitor test, to be honest, you need to be able to provide evidence first during the administrative procedure showing that it's not possible for there to be a foreclosure effect. And they said, since you didn't do that, you just asserted that that was the case. You never actually provided any evidence. We don't have to do an as efficient competitor test. And so they dismissed that ground. So that's kind of like the short version.
Great. Now we move to Lena. I'm pausing because I'm double checking which journal you published the paper. I think it's Journal of Competition Law and Economics.
My paper.
No, Matthew, we published
Competition Law and Economics.
Yeah. So I was double checking, and as I lost the picture. Yeah. Now we have Lena.
Yeah, well, for me, this is the part of the judgment that I I might say less familiar with. So the only thing that I could add or that I got from it is that the test is not mandatory. So the as efficient competitor test is not mandatory. It can be an element, but it doesn't need to be conducted necessarily. Only that if the commission does it, and that I think that's what Intel is telling us, is if the commission is doing it, then it needs to fulfill certain standards. But here in Google Shopping, you could prove anti-competitive effects in a different way, or even potential anti-competitive effects in a different way, and that is sufficient. And so the as efficient competitor test is not necessary.
Christian.
Well, one of the perks of age and maturity is that you remember the past. And today it's pretty vanilla that the AAC test is not mandatory, but we have to go back in time. The commission's decision was opened, 2010, based on a complaint from 2009. The year before, the commission has put out the enforcement paper, and going back to 2005, they put out the discussion paper. Particularly in the discussion paper, but also to a large extent in the enforcement paper, the commission link Article 102 to consumer welfare, and they kind of indicated what I believe was an ambition of only doing cases if you could actually establish anti-competitive effects and consumer harm using the AC test. So I think that Google's initial position was a very prudent and wise decision, saying that, well, how can you advance a case where there's obvious, anti-competitive effect in terms of consumer laws, because everything is free and people love this. But of course, as the case moved forward, that was a position that makes less and less sense. But Google just stuck with it. And today we're contemplating and don't really understand, because we've got a series of ruling that you don't need to do. It's not mandatory to do the AC test. It's just one among several. And in an environment where everybody is, is free, and Google is, not only super dominant, but they are ultra dominant, it doesn't make any sense. But at the time when the case opened, it was actually the commission's official or unofficial position that they needed to do that. So of course the Google pointed out that, you haven't done that.
Okay, so we have covered the four grounds, and there are a few more questions which I wanted your expertise and juristic wisdom to articulate and highlight. And the first one with the order: Lena, Christian, Matthew, and relevant markets. So we were talking about vertical search and horizontal search, which are interlinked but very different strategies as well. So what is the situation with this criterion?
Yeah, so as far as I understand it, because in at least the Court of Justice judgment didn't play such a big role anymore. The markets that were relevant in this decision were first, the general market for search and then the market for comparison shopping services, which in Google's case were vertically interlinked, and I think what is interesting, and what also you could, like, if you read the Court of Justice's judgment, you think like, oh, they've read some academic papers, because they use like terminology like leveraging abuse, all of this, things that do not necessarily appear, in the decisions before, that they, in terms of relevant market, I think what is interesting to see is that as part of this discriminatory plus elements, the Court of Justice focuses on this interlinkages of markets, and that you leverage market power from one market to the other, and that this contributes to the abuse. I think for me that's the most important or the most interesting part when you look at markets, that they are connected. And at academic conferences we always talk about what is the role of these big networks and multiple markets that are where a company is dominant. So I think this is a nice example to show that this can play a role in practice.
Thank you, Lena. Christian?
When we turn to the digital realm, everything gets complicated. We are used to having markets that are clearly separated, but there can be a link. But here we have some markets that are alternative. They are separate, but they are also linked and they are overlapping. Let's start by explaining that when you start to navigate the internet, you sort of have two ways of doing. You do a general horizontal search. That is what Google does. That's also a market. But you can also do something else called a vertical specialized searches. And if you want to go somewhere, you will go to Expedia or Booking and get a hotel and travel. That is also a market, but it's also a way of navigating the internet. You can also do shopping, which is also a specialized search, but it's also a separate market. So we have a situation where one of the way of navigating the market is the internet is a separate market and a service. And some of the others way of navigating the internet are separate markets. So we need to understand that this is, of course, something that is slightly confusing. And I think this creates a lot of confusion when we talk about the developed market. But if you start understanding this, it gets more easy to understand the market definitions. Of course, also complicating is that they are converging. And DG.com said that Google's motive for doing that was not only to profitize, by monopolizing a separate market, but it's also to prevent that market could be a jumping off point for attacking the core product, and that is, of course, the search markets.
Thank you, Christian. Matthew?
I probably don't have a huge amount to say on this, but I will say that it is more complicated with digital. Markets tend to merge, so what is clearly a separate market 15 years ago might not be a separate market now because increased functionality gets integrated into products, and so you end up with a situation where people sort of tend to blend and have these overlaps. But as far as I'm concerned, the only thing to add is that the CJEU didn't really seem to use the terminology vertical or horizontal, so they just stuck with general search and specialized search. So perhaps they were trying to avoid that idea of having to decide what's horizontal and what's vertical and just leave that aside. And they just kept using general and specialized search, and that's about it.
Okay, so I'm mindful of time, and I propose I probably pull together the next two questions, and they were basically if you identified any interesting heuristic novellas or some formulas or some solutions, some algorithms which could be somehow operationalized in your research, or which you want to share with the community. And the second question was originally, but maybe we can combine them. We see that commentators adhering to different normative positions, being prudent lawyers, extract wisdom in favor, in support of their position. Is it an artificial or endeavor, or you can definitely see that some elements, some formulas, as I think Matthew mentions something of this kind at the beginning of conversation, can backfire essentially for the strategic pro-enforcement position. Christian, Matthew, Lena, it's the order.
I don't understand why anybody can claim that Google is evil. That company has given us so much to discuss. I think we have to be fair. This is a really, really complicated case, and I believe that I'm understanding it. But to be honest, there's still some aspect that are is open for discussion, and that means that some of the things that I have shared here today, that is the way I read it. But I completely accept that there are different takes. Now the problem is that a case so complicated, you eventually become locked in a position, and a lot of people out there has been acting on behalf of Google or the other side, and they're also sort of locked in a position. So that means that there's you can read a lot of into the case, and that supports your initial position. But you can also, depending on, if you are paid for having a position, you can also find a lot of stuff in the case. So that means that, there's a lot of ideas circulating, and, I think I know which ones are right, but to be honest, I might not be. But there's one thing I would like to share, and that is, I think it has been fascinating but also frightening how the narrative on big tech has completely changed. You know, I remember when everybody loved Google and Meta, etc., and they were just simply above the law, and then, you know, there was nothing that they couldn't do anything wrong. And now it has completely changed, and they do not have any friends at all, except the academics.
Matthew.
So the thing that I'd like to draw out from the case is actually to do with the as efficient competitor test, which, as you kind of alluded to, I've kind of written on before, so it's a particular interest of mine. And it only makes up a couple of pages of the entire judgment, so they obviously dealt with it in quite a quick, cursory way. But I find it really interesting that since the more economic, supposedly economic approach has been kind of applied within the EU, there's been this desire to be more economic, and this has largely incorporated a focus on consumer welfare, which is fine. I'm not really going to discuss that, but also this idea of a focus on efficiency, which is the idea that you should only protect competitors that are as efficient as the dominant undertaking. But the thing is that I think what people don't understand is there's two ways of interpreting what efficiency means. There is a technical economic definition, which is merely to do with costs, right? All it means is that if you're efficient, you have lower costs than another company. And this is very useful if you're talking about a homogeneous good. So if you're talking about two companies that make cement, and one makes 10 tons of cement and the other one makes 10 tons of cement, and one of them makes it for half the price, you can say the one is more efficient because it has lower costs. But also, it's essentially the better company because all they're doing is producing cement. This breaks down when you have heterogeneous products where they're very different and they serve different kind of things to different people. I mean, I might have a Microsoft laptop, you might have an Apple laptop. If one has lower costs than the other, does that make one company better or not? Hopefully, I might be losing you guys, but what I'm saying is if you use efficiency merely as a measure of costs, which company has the better costs, the as efficient competitor test doesn't really make sense to apply outside of the context of a pricing abuse, right? So the idea that you're going to try and apply it to everything just makes no sense. There's another sense of talking about efficiency in probably what you and I would use in more common day-to-day speech, which is the idea of something's just better. So if Lena is a far more efficient lawyer than me, for example, then that might be the suggestion, not that she takes less money to do the same thing, she's just better at it. She gets the job better. And I think this is how the term is used in the Google shopping case. Because for the first time that I know of, at least, maybe this has been used elsewhere, and if anyone else knows, feel free to tell me about it. But this is the first time that they've basically used as efficient to mean as effective. And they set this out expressly. So if you look at the end of the case, they actually use the term, wait a minute, it's, if I got a quote here, the CJU summarizes Google's argument the Commission is required to examine the effectiveness of competing shopping services so as not to protect less efficient undertakings. So we've got this very strange situation where they're trying to imply into the law the idea that before you protect a particular undertaking from being excluded, you have to check whether they're as good as the dominant undertaking. And for me, this is both interesting but also disastrous because courts are not in any position to tell you which is the best company. They can work out who's got the lowest costs, but they can't tell you who's best. Essentially, the consumer decides that. If I go back to my laptop analogy, I might think a Windows laptop is the best thing ever, and OLEDs, you might absolutely hate them and think Apple's the only way to go. How is a court to determine which one's the most effective producer of laptops? And so, without going into too much detail, because like I said, I could probably ramble on this for far too long and you'd all be asleep. Essentially, I think there's going to be a lot more cases on this because I don't think the court's really sure of what it means to have an as efficient competitor test. Like I said, there's two different conceptions. I'm not sure they know yet which is which. I don't know that the Commission does. And I think this is only going to be hammered out by more companies trying to throw this challenge in. And eventually they're not going to be able to swat it away. And we're going to have to actually know what is efficiency. And until we sort that out, this problem's not going away.
And on the record, Matthew, we are not losing you. We're following your scholarship. So which of the latest two papers on ordoliberalism or on as efficient competitors is more relevant to this to go further for those who got caught by your idea?
Oh, you're very kind. You give me an opportunity to give a plug. So there is a paper in the Journal of Competition Law and Economics, and I discuss this partly in that paper in reference to the Intel decision, where they start talking about as efficient and trying to protect efficiency. And it doesn't really matter which definition you go for. This, and I could kind of explain it in probably in another paper, but it's not effective. It's not efficient for us to try and do this. I think it's trying to import the conception of being more economically accurate, but in reality, you're trying to make the court guess, or the authorities guess, what companies are better. It's almost like trying to get the government to pick national champions or to pick winners. It doesn't make sense. The idea of competition law is to allow consumers to choose which products are best. And if you try and force the court to do that, they're only going to make mistakes.
Thank you, Lena.
Yeah, maybe before coming to your question, just one reaction maybe to what Christina said in the beginning. So what does everybody take out of it is a bit different, and for everybody, as you see in our discussion, different aspects are more relevant. But I think when it comes to the Court of Justice, I think we need that, and we need the different views also in literature and writing about the case, because what the Court of Justice in the end is very, you know, authoritative. It's the style of giving judgments, even though this is already a very long judgment, is more, you know, this is the way it is, but there are not so many arguments. And I think it is left to, you know, academia to find arguments. We don't have things as, you know, dissenting opinions. And in the case, there are very few, you know, arguments by the court. It's more, this is the way it is, deal with it. So I think it is a bit our job to find or to supplement arguments that maybe the court is not doing. And so I think that's that's why, I don't want to become unemployed. Academia is very important. But coming back to, you know, what I personally take out of it is, I think what is nice to see is that, you know, 102 or in general EU competition law is flexible, and it can take in new abuses as now. And we are only at the beginning. I think that's what we've discussed now. Now we know a little bit what can be, you know, this the abusive leveraging type of abuse. And down the road, if we have more cases, we know more, we gain more legal certainty. But what we don't know, what we don't need, or what, you know, EU competition law in its constitutional value doesn't need is, you know, rewriting all the time. We have the rules, they have been there from the beginning, and they're flexible enough to cover new types of abuses. And after a while, sometimes it takes 20 years, you have at least the first standard. So that's why I think, you know, the system is good as it stands, and then maybe you need extra things in terms of procedural efficiency. That's why we have the DMA and other things, and I'm sure we talk about it in a minute. But in terms of law, you see once again, you know, that there's a reason behind all of this.
And let me ask you, not as an academic, but in your capacity as an editor of Clover Competition Law blog, how many submissions you have already received from different perspectives, or you anticipate to receive in the foreign future?
A lot. Usually it takes a while with these judgments, you know, sometimes they come all at the same day. But I think with these things, because you know, we've been writing about this and talking about this for such a long time, there will be many things on the different aspects, I think, and that sometimes takes a while before people make up their mind.
All right. Okay. So again, I pulled together two questions about the remedies. We hear about inefficiency and pecuniary remedies is not enough. Money is just cost. You sign off it as a kind of part of the routine. What kind of remedies would you anticipate? What does the case kind of channel us to, or would be more efficient, necessary, or depending on which model you would envisage? And also combining it with a second question on the DMA, as Lena said, copy-pasted essentially the theory of harm. in the obligation, but also with my kind of more proactive modality. Somehow you can not only compliance per se, but also regulatory dialogue where you can somehow nudge gatekeepers towards a specific conduct. Is there any specific conduct which we would expect ameliorate significantly competition in these specific markets? And the order this time is Matthew, Lena, Christian.
I think, I mean, combining the two together, you can see that EU competition law's got a problem in terms of whatever kind of remedies you're trying to think of. If they take 20 years to be applied, we've got problems. You can also, there seems to be possibly an issue with the fines. These are big fines. We're talking, you know, billions of euros. But when you have companies as big and as profitable as Google, I guess the risk is for the Commission that they can afford to pay it as long as the money keeps on coming in. So it's interesting to see what the EU is actually going to really meaningfully be able to do and how quickly it's going to be able to be done. I think the DMA is probably the big thing that needs to be considered in this regard, because what has been proved over the last 20 to 25 years is that the current way of applying the law is too slow. Ex post doesn't seem to be working. By the time you find the company, by the time you reach the final decision, if there was any damage to the market, it's done and there's no way to restore it. So I think it's important to probably look to the future. And although it's useful that this decision's come out and it kind of endorses the direction that the Commission's going in, ultimately, I think the DMA is going to be the future. It's stripped out a lot of the economic analysis, which can be challenged and slows things down. And so I wonder whether this will help speed up the outcomes in actually protecting competition that the Commission's been trying to achieve in a much more effective way than dealing with it through Article 102 and 101.
Thank you, Lena.
Yes, well, remedies and DMA. Well, the remedies, I think, and I mean, first of all, it was a big discussion when it came to the abuse, like what the ultimate remedies play a role in terms of defining the abuse. Because I think what Google tried was, because the remedies was also giving access to the boxes, it means that, you know, we have a refusal to supply or an access problem, which at least now we know this is not the case. So you do not define an abuse from the remedies. I think that's one very clear outcome. When it comes to remedies, I think in general we need to rethink, or the EU needs to rethink how to do remedies, because just fining companies, I don't think it makes sense anymore. You know, it's in the companies calculated into their yearly budgets that there will be a fine. You know, the minute the proceedings start, they know, okay, we will at least have to put this aside, and it doesn't change a lot of behavior. That is what I would say. I think in terms of remedies, we would more think of, you know, what are the actually affected parties? So what are the competitors? What are the consumers? How can they benefit from any remedies? So can it be, you know, compensation directly? Can it be some form of access, as in this case, or maybe sometimes even, you know, cease and desist is something that is sufficient. And specifically when it comes to compensation, you know, you hear always the competition authorities, no, it's not our job. You need to go to the court. You need to claim damages. And we already see in Google Shopping there are some private actions already happening. And now that we have this like really definite judgments, there will more be following. And we have the same discussion in 30 years still. I mean, I do a lot of research on private enforcement, and what we see there is it takes forever until they have really established systems working. And now we will have another 20 years of discussing like how and to what degree the private enforcement will work in these cases. So why do we not have a little bit more in terms of remedies already at the competition authorities stages to actually think of affected parties? I think that needs to change. And when it comes to the DMA, and I think, Olish, you were there at Ascola this year at your panel. I don't know if it was even you or who was it in your panel who said, well, the DMA in the end, it's procedure. Was it you, Olish, or who was it? Do you remember? Well, I don't remember so much. I just remember it was in your,
Probably Alba.
panel. Probably Alva, exactly. And I think you see with this example perfectly how the DMA in the end is about procedure and procedural safeguard, to have quicker procedures, to have very definite legal standards, be it right or wrong, that needs to be also litigated, but it goes much faster. And what we see already with the designation decisions, with the first non-compliance decisions, and so on, this is already faster than what has happened in Google Shopping. And I think we do not need to seize, or we do not need to assess so much all of this from a substantive law perspective, but more see it from a procedural perspective and see the DMA as also in this case perfectly demonstrating on how different procedures can look like, and how to things like reversal of the burden of proof, things as presumptions play a big role for practice and for effective enforcement is much more important than talking always about the nitty-gritty of like different theories of harm.
For me, DMA is a microcosm. I would probably use the vocabulary or something more esoteric. Christian.
I'm tracking approximately 150 antitrust cases into Google. I don't think that Google's main concern is the fines. I think the main concerns are the manageable resource, the management resources and the drain invested, and of course all the lawyer fees invested into all these cases. And I think that the reputational damage is actually much more worse. They are referred to jointly with other companies as digital gangsters. And after the deposition of the CEO of Google and other companies, they were referred to as the Gang of Four. I don't think they like that. So I think that, of course, having a huge fine is unpleasant, but I think that the main concern is actually other stuff. When we talk about the DMA, I think that is, to me, was a political necessity, because everybody wants to regulate Google and Meta, but it doesn't make any sense that you have 27 different kind of regulation applying to one company. So there had to be one. So I think that a DMA was a political necessity to preserve the single market. And when it comes to punishment and remedies, I think the naming and the shaming and the cases is sufficiently unpleasant. But having said that, we don't even know if Google is compliant with the 2017 decision. Google has changed its policy, and they claim that they're compliant, but there are voices out there claiming that they're still not compliant. So until the commission kind of decide if they actually are, we don't even know if the remedies is sufficient.
The last round before asking you your recommendations for students, I pulled together questions because of a shortage of time. They merit a separate discussion, I'm sure, and it's a pity. The private enforcement, and the order is Lena, Christian, Matthew this time. Private enforcement is the first issue. What would be the implications? This has been already alluded by Lena. And the second part has been already alluded by Christian. Namely, we have pretty much, on daily basis, we hear about another jurisdiction either opening the case or considering or even making a decision. So obviously there is no coordination, etc. But what would be the cumulative effect of this cascade of decision in the following years? Would it be again it's not monetary. Is the focus on reputational damages, or should they think about trying to somehow to hear what competitors want, which kind of competitors, are they kind of verticals or horizontal? Is it even realistic? So all these kind of more broader societal implications combined with private enforcement. Lena, please.
Yeah, well, I would say in terms of private enforcement, as I said, we then enter an era which has other uncertainties, which are just inherent in private enforcement. You know, you have now a definite commission decision that has binding effect for private enforcement purposes, which is great in terms of finding an abuse. You know, now you know what the abuse will be, but the main issue in private enforcement would now be, okay, what do we want? If we want damages, which will be the follow-on cases, the next, you know, tier of 20 years will go on in how to now really calculate damages from a period that has been a long time ago, damages in terms of volume that are very hard to calculate, because we have here a non-price based abuse also, you know. So how to end up calculating the damages, that will be a huge problem in any follow-on damages cases, and even in cases where we have really hardcore cartel cases. So for example, what in private enforcement, what everybody's talking about for the last 10 years has been the trucks cartel, where I would say the anti-competitive behavior was pretty straightforward, and the effects of, you know, cartelized or cartel behavior on markets is much more researched, and that's also why, you know, it is to a degree, even there's a huge discussion on how to calculate damages, but there at least, you know, there's more research there's more out there. Now when we look into abusive behavior that is kind of novel and on markets that are non-price based, I think to have now these follow-on damages actions will create a lot of incoming litigation. Good for lawyers, but, you know, again, for legal certainty. And here the whole private enforcement system in the EU is a bit flawed, because what we've seen with public enforcement, that, oh, it takes 20 years to reach a decision now, a definite decision. And now, at least for public enforcement, we have the DMA, where it's supposed to be quicker and more efficient in terms of procedure. This is still lacking in private enforcement altogether. And in these specific cases on digital markets, with these kinds of behaviors, it will be very, very hard to litigate all of this, and it would take a lot of time. Not that not many people are trying it, and I think that's also necessary to do it. Otherwise, in terms of, you mentioned all these proceedings in these different jurisdictions, I think reputational effects are really one thing, but maybe we can also see this positively. Some of them will certainly reach, you know, the Court of Justice, and then we have this desired further clarification of the notion of abuse we talk about. So that could also be a positive to see, you know, the different nuances of what could be this leveraging abuse.
Thank you, Christian.
The truck cartel is the biggest claim for damages case that I know of. You know, all the law firms and all the lawyers that I talked to here in Copenhagen are involved. You know, they're representing either a victim or one of the cartelists. But if we look forward, I actually think, you know, Google could be even bigger. You know, I already know of 3 claims for damages pertaining to the Google Shopping, and, you know, some of the victims are claiming amounts that even in America would be crazy. But if we look a little more ahead, you know, the ad tech case could be even worse, because, you know, potentially Google has cheated everybody who has online advertising. I'm not saying that is the case, but potentially. And if you contemplate the, you know, combined potential loss, that could probably be the biggest lawsuit ever in the world. So I think that there's definitely something to look forward to, particularly if you are a lawyer, and you know, everybody else can look into the cases from the outside. And of course, you know, if I was at Google, this would be a nightmare, not only in terms of what I had potentially to pay, but also managing all these cases. You know, it would be so stressful in terms of internal resources to, you know, to feed all the lawyers and make certain that what is disclosed in one jurisdiction doesn't have consequences for a position in other jurisdictions.
Thank you, Christian. Matthew?
I agree. I don't think I've got anything to add beyond that. Thanks.
Okay, and the traditional question about recommendation, maybe I can combine it with or rather focus it to this kind of walking against the clock 24/7 and still expressing happiness and how do you manage to process so much information effectively? Maybe you can offer some tips to students how they should read cases and put this jigsaw puzzles together. The order would be Christian, Matthew, Lena.
I'd Google it. I think if we take the bigger picture on Google, there's just simply such a powerful story to tell. Because I have a presentation, I even have a YouTube video where if you really want to understand, you have to go back in time. And of course, depending on how much back in time you want to go, you can go back to Nixon, but you can also go back all the way to the American Civil War to understand, that in the course of the 70s, the 80s, we kind of settled on the consumer welfare standard. And everybody thought that was the right approach, but once we needed to go into the digital sector, it became problematic to establish there was anti-competitive effect if you rely on the consumer welfare standard. So Google has actually reopened some discussion that generally was understood to be closed in the 80s. So the point is that in my presentation, I kind of tell the stories to the student that Google is, you think it's something new, but actually it reopens old discussions. And there are different concepts. We even got somebody calls those who doesn't like Google as hipster antitrust. I don't think it's fair, but it's entertaining. So I think that this is actually something that should be turned into a Netflix TV series. And when I tell the student, they really think it's funny. But I actually believe that there is a much larger story, and it's not that often we have antitrust stories that ends up as a Hollywood movie. We got a couple. Hoffman La Roche was turned into a movie. The Lucene Cartel was turned into a movie, and I'm really much looking forward to there'll be a movie about Google. And yes, I would be available on a consultant basis.
Matthew.
In terms of advice to students in trying to work out what to read and how to read it, it's an interesting one. I'd probably say whenever you're reading cases, and often you do, as much as textbooks are great, but if you really want to understand the detail, you do have to go back to the cases, and you do have to look at the detail, and you do have to look at the content or the context. And those two lines which neatly sort of summarize things in the textbook often aren't quite enough. If you want to go through a large amount of information quickly, learn how the courts structure their decisions as best you can, because once you work out how they set things out, you can usually zoom in on what you actually care about and what you actually need an awful lot quicker. If you read every single word on every single page, which, don't get me wrong, is a very thorough way to do it, you will also be weighed down with an enormous burden of work. So what I would say is work out how things are structured, and then you generally can go, actually, I don't have to worry about that. I don't have to worry about that. And then you find the bit which is relevant, read that, and read it twice if you have to, maybe 3 times, and that will be far more profitable, I think, in the long term. That would be my advice to students.
Wrong. The right advice. Go and watch Digital Markets Research Hub discussion. Lena.
Yes, I mean, Matthew, you took away my tip, which is like, you need to learn how different courts structure their judgments, and then it's actually not that much. And I think that goes back to a general tip you can give to students is like, don't, I mean, first of all, if you don't like to read, maybe law studies is not for you, or any studies, but there are job shortages everywhere. We need a lot of handymen. Like, not everybody needs to be a lawyer. If you want to be a lawyer, I think reading a lot is something that you should like, but then be smart about it. You don't need to read every book cover to cover, not even every article cover to cover. Sometimes, you need to, after a while and after practice, you find out, okay, which are the key articles where you can really drive something from, and also in the judgments, which are the key parts. Learn how different courts structure different their judgment, and it's a bit different. And with the Court of Justice, in the end, you find like these couple of pages that are really relevant, and there there go into detail, be smart about it, don't read everything, but when you find the interesting stuff, go into detail, read every word, and also you can be sure that every word has a meaning and that it can be interpreted. And then I would always say, or I would always recommend, stay away from complexity, like break it down. And in the end, and I think I need to quote Philip Marson here, who did a keynote at a conference last year that I organized about what if competition law was easy. And he even broke down competition law being easy in 10 rules. It's in the editorial of our book. It's open access. I will put it in the show notes, as we call it. And it's really perfectly demonstrate, like, take a step back and think about it in easy terms. Like, how can we, out of these, God knows how many pages judgment, how can we break it down and explain something in a few sentences? How can I explain Google shopping to my grandmother? These things. And you should always, as a student, think about, okay, everything looks super complicated, but it has a dogmatic and it has a structure behind it. And I think it's important to break it down into these very, overarching topics, and then it's not as complicated.
Exactly. Lena Hornkohl, Matthew Cole, Christian Bergqvist, thank you very much indeed for this fascinating conversation, for your time, expertise, and your amicable and in-depth discussion. It was a pleasure to see you.
Thank you very much.